thank you for the opportunity to add my voice to the debates on this bill. Mr. Speaker, Honorable Nitiwu took us through some issues, and my colleague who just debated further highlighted some points I have here, and I would not repeat all of the points they've already argued. But Mr. Speaker, it is important to underscore one fundamental issue: that the memorandum before us does not provide any empirical evidence to suggest that Act 1030 has failed. Mr. Speaker, it appears that this bill is more founded on partisan political interest than a national security interest for good governance. Mr. Speaker, without doubting the competence of my own senior, Honorable Muntaka Mubarak, I think that he's been overburdened handling Interior Ministry alone, with all the agencies there too. Can take away all his energy. Then he has a further oversight responsibility as National Security Minister. Mr. Speaker, is he a National Security Minister responsible for the security of the state, or he's just there for the mere presence? Is he dormant or is active? To what extent is he in charge of those responsibilities as a National Security Minister? Mr. Speaker, I think that our democracy has come of age. We as the political actors must begin to move away from those parochial approach to governance. You are in power today, so you see everything expedient with changing certain fundamental principles, because as I overheard somebody saying somewhere, we are in power. Mr. Speaker, it is not enough to say you are in power. So you will change the architecture of the security of the state, even when it is not going to help the country. Mr. Speaker, we have a National Security Coordinator who is not going to be responsible to Parliament. Mr. Speaker, I recall that in the enactment process for Act 1030, the key argument by the then opposition, the minority in this house, was to the effect that bringing in a minister responsible for national security to be appointed as a bona fide minister for that institution of national security would help with that interface between the people and government. And Parliament can summon such minister to answer questions and explain matters. Mr. Speaker, it is the reason why Parliament itself, in its new rules, created a new committee for intelligence, the Security and Intelligence Committee. And Mr. Speaker, we even went further to say that to be a member of that committee, you must take an oath because of what may come to you, so that members of that committee will not be one of those committees that you are working in and acting partisan, because you are going to receive sensitive information, sensitive intel that may affect the nation if you disclose. So we created an architecture where the minister will report to Parliament, work with our committee, and then ensure a seamless relationship. Mr. Speaker, what this bill is doing is to do away with all the gains we have achieved the last 4 years. And by the way, the coordinator, how is he to be appointed? We are not referring it to Article 195 of the Constitution. So the president would just appoint anybody, sit there, you are my coordinator. When even ministerial appointment, the Constitution provides that that minister must come through Parliament. And in Parliament, there are enactments like OSP, the Office of the Special Prosecutor. The Special Prosecutor comes to vetting. Parliament vets the Special Prosecutor. Why would it be that the coordinator, National Security Coordinator, will be a law to himself and will be a lord who is not answerable to anybody? And we are starting it right from here. If we create ambiguity in enactment.
Minority Leader, the minister is on his
Very
seat.
well.
Let me recognize him.
Thank you, Mr. Speaker. Mr. Speaker, I want to catch my colleague, the Minority Leader, on point of order to say that he is misleading this House. Because we've operated from Act 526, like earlier mentioned, for 24 years, and equally operated under 1030 for 4 years, so that's 28 years. And both 526 and 1030, the coordinator is appointed under Article 195. So this argument that you are making is, with a greater respect to you, something that we've been practicing. And then the issue about if somebody is responsible for national security will enroll or derail all the gains that have been made. Since we started a year and some few months now, I have been designated as a minister. I've responsibly been in this House to answer questions. I've gone to committee to give briefing. I've done everything this House has ever wanted any minister of security to do. Yet, I've just been given only an oversight responsibility. So it's not something that is new or something extraordinary that is going to weaken Parliament. If you care to know, look at the committee's report. I don't know whether you've taken time to go through. You will have seen that in the committee's report, there's even a new addition about how this House could place an oversight on the security and intelligence sector. So please, Mr. Speaker, I think my colleague should straight to whatever contribution that is made, but then it doesn't create an impression or mislead the House to, as if something untoward is now coming. What we are coming to do is not much different from what has existed in the past. Thank you, Mr. Speaker.
Mr. Speaker, before I go on with my submission, let me register this protest. Mr. Speaker, it is unacceptable. It's unacceptable for the Honorable Minister, who has his own opinion on this matter, to smuggle it in under point of order. He has an opinion. He should state it when the time comes. When we are done, he as a minister has every right, unfettered, to make his point known. And any point of a disagreement with my submissions, that will be the right opportunity to do so. I mean, at least, let's be fair with each other. Mr. Speaker, my point here is that in the existing dispensation, we created that national security architecture and made it a ministry. Under Act 1030, a ministry was created, and the minister was made responsible for that sector, who was to report to Parliament, just to ensure that there's a seamless relationship with Parliament. Mr. Speaker, this new enactment, what is being proposed, so much power is being given to the coordinator. It is not clear clear how his powers are going to be fettered. Mr. Speaker, my submission is that if you give such powers to the coordinator and you do not provide for a clear path of responsibility, accountability, and oversight, it becomes problematic to you yourself as a government. And when the rights of citizens are being abused, the man will come and tell you that in the name of national security, it is because I am relying on intelligence. Mr. Speaker, but if we bring clarity to the issue, Mr. Speaker, it becomes difficult for such people to, Mr. Speaker, as it were, take advantage of the law to abuse the rights of citizens. Mr. Speaker, if you go through the memorandum of understanding, it does not also explain how the so-called duplication concerns with the existing institution will be addressed in practice beyond the general coordination language. There's no explanation. If you go through clause by clause, they have not addressed the issue of duplication. So what duplication are you addressing? Mr. Speaker, if you go through the bill again, it is clear that the measurable gaps in coordination that are supposed to be documented are not found. Whatever gaps that, according to the minister, have been identified, Mr. Speaker, it is expected that in this bill we find them. So there are no such documented gaps. You are not telling us that in the existing legislation these are the gaps you've identified, and therefore you are introducing these new clauses to address them. Nothing like that is said. Mr. Speaker, I am interested in Article 18 rights. No additional protection is introduced to safeguard the rights of citizens when they are violated. Mr. Speaker, we cannot have a bill of this nature when we know that this bill will deal with human rights issues, yet we do not safeguard them. We allow so much ambiguity. Then by the time a citizen goes through the judicial process, he would have lost a whole lot. Mr. Speaker, when we give them the right to the power to even freeze people's accounts, freeze assets, and we do not provide for a procedure that would allow the right thing to be done. We heard about what happened to the former governor of Central Bank. We heard what happened. Somebody goes to his house and says that I had a court order. And later when we're asking for the court order, we all know the ex parte application, Mr. Speaker. We shouldn't wait to get into a position before we find everything wrong with the law. The National Security Minister or the minister responsible for national security who is sponsoring this bill must safeguard the right of citizens. It's their right, far right. We know what is happening. In the name of national security, rights are abused, and at this point, as the people's representatives, we are enacting the law and we do not want to put in these safeguards. It will come back and haunt us. I believe that at the right time, during consideration, we'll look at it. But it is important that I bring this to the attention of the minister and my respected colleague, the chair of the committee, so that we fully tackle this. The provisions in there are insufficient. I respectfully submit. Mr. Speaker, I am also concerned about the oversight mechanisms in this new law. Mr. Speaker, this framework doesn't appear to strengthen oversight mechanisms. And here I talk about Parliament. The Committee of Intelligence and Security is not given a clear, defined role in ensuring proper oversight. Mr. Speaker, not too long ago, we heard about the Attorney General in a public interview talking about some operational funds and how that operational funds has become a matter of some litigation in court. Mr. Speaker, don't we think as a house that this is the time to at least strengthen Parliament oversight on some of these matters, so that the committee whose members have taken an oath can interrogate some of these things, bearing in mind the essence of time, because Honorable Niti will argue that issue, that much as we want to put in place some measures, we should also ensure that we don't delay the release of funds for operations. The system that we put in place must be said that we balance oversight with prudence when it comes to operations. Honorable Minister, that in my view is also missing. Mr. Speaker, let us look at Article 21, 23 conjointly with 18. Mr. Speaker, 23 and 21 are very, very fundamental. We are dealing with issues of administrative justice. How sure are we that this bill will not give the security agencies that continued unfettered right to be using ex parte applications in the name of national security to continue to abuse the rights of citizens, especially those who do not have the means to employ lawyers to defend them? Mr. Speaker, many of our citizens are poor and cannot afford legal representation. For these citizens, they must be in our contemplation at an important juncture like this whilst we are enacting this law. If we don't bring clarity in this, Mr. Speaker, we'll be creating problem for the many who may not have the means to get high-class legal representation. And what happens to them? They will go to the BNI and then they will be told that, oh, you write this statement and just have your bail. They will write the next moment, they go to court and they tell them that, my lord, he said he admitted to the offense and he's guilty as pleaded. He doesn't have a lawyer. The next moment he's in jail. There are many more of such cases. Mr. Speaker, I am a practitioner in our court and I know many situations that people don't know about their own rights, and our security agencies have relied on laws to deny them their rights.
Yes, Majority Chief Whip.
Mr. Speaker, the minority leader is a senior member of this House, and he knows that he cannot depart from the terms of the report and move into anticipation. Order 1251 is clearly in breach of Order 1251. He can't do that. He's anticipating what will happen tomorrow, what will happen the day after tomorrow. You can't do that. No. The law, there are rules forbid anticipation. You can't be arguing in anticipation in respect of a report, the terms of which are very clear before you. You can't be arguing in a preemptive manner, anticipating that this will happen, that will happen, and that will also happen. Mr. Speaker, he's a senior member, he's a leader. We learn from him. He's a leader. He should stay within the terms of the report.
Honorable Leader, take note of the observation and also take note of the fact that clause 29 to 31 is a repetition of Act 1030.
Mr. Speaker, with respect, to the extent that my colleague suggests to this House that I am going outside of the issue before us, Mr. Speaker, I would like to respond for Hansa to also capture same. Mr. Speaker, I strongly disagree with him. At this stage of the lawmaking process is where all issues and concerns are expressed. The matter I raise has to do with what happens in our courts. And I am saying that I have witnessed situations where rights are abused because such citizens who came into contact with the security agencies in one way or the other did not have to have access to representation. Mr. Speaker, as a result of that, they suffer some injustice. All I'm saying is that if we are enacting, it is important that we bring clarity and safeguard the rights of citizens. We should provide for these so that the security agencies, as part of their own administrative duties, will be guided. Mr. Speaker, until we ensure that citizens were not detained beyond 48 hours, until all of us spoke about it, that this is enshrined in the Constitution, there were times that citizens were detained by security agencies beyond 48 hours. But Mr. Speaker, because the law is clear and unambiguous, such abuses have limited. Even so, such abuses have not stopped. Mr. Speaker, I would want to say that the over-concentration of power in the appointment process without Parliament having the opportunity to vet is a matter of serious concern that this House must look at even as we go into the consideration stage. Mr. Speaker, two, I have also identified a weak accountability mechanism. It is largely dominated by the executive oversight rather than parliamentary oversight. And I've stated that and I will not repeat it. Mr. Speaker, I also acknowledge the fact that there must be some level of secrecy. I agree, national security issues must not be made public. However, I need to repeat for the record that to the extent that Parliament itself in its wisdom has enacted its regulation that creates a new committee responsible for national security, Mr. Speaker, there must be unfettered disclosure to the extent that members on that committee, Mr. Speaker, have taken oath. Mr. Speaker, looking at this enactment, it appears again that there is some broad, rather loosely framed, intrusive powers and weak warrant regime. Mr. Speaker, I would delve deep into this when we get into the consideration stage. I've already emphasized what happened not too long ago with this warrant for search and all of that. Mr. Speaker, this law does not address it fully. And it appears that, Mr. Speaker, what we are seeking to do is to create a much more intrusive institution. We are allowing a new warrant regime, complicating matters, and this would further affect citizens, especially political witch hunting. Mr. Speaker, we should also be mindful of the politicization of the regional and district security councils. Those regional security coordinators and the district security coordinators, if you go through the enactment, we do not define their essential qualification for appointment. Are they going to be party members who would be given job for the boys, so you are district security coordinator or regional security coordinator? When they see somebody's cassava in a pickup, they go and chase you. They say, for national security reason, we stopped you. When they see that there is a car going somebody has bought his new car, they will chase you and come and say, where did you get money to buy this new car? Mr. Speaker, I say some of these things from experience. Just about a month ago, my own pickup was chased by a so-called regional security coordinator and arrested the driver and said that, he has information from national security. Meanwhile, it was not true. When he realized that the car was mine, he said, sorry. Meanwhile, he had arrested the guy, frustrated him, and I don't want to say he extorted money from him for not having a registered car. Mr. Speaker, if such a person was a professional and by enactment he has gone through the vetting process of appointment and knows what he is supposed to do, Mr. Speaker, he won't do such a thing. So, Mr. Speaker, this bill must also look at it carefully and not just think that because you need to have certain positions filled, anybody at all should be there. Mr. Speaker, I shall conclude by saying that this bill does not reform the security architecture of our country. It rather entrenches it and worsens it. Mr. Speaker, the bill preserves the old problematic architecture without substantive reform, carrying over existing appointment and practices. For these reasons, Mr. Speaker, I believe that though the committee has done a good work at consideration, there will be the need for the minister to sit with us as a house, do further winnowing, and incorporate the major concerns raised by the minority on this floor, so that, Mr. Speaker, in the end, we would have a bill that is citizenry friendly, a bill that ensures transparency, a bill that allows Parliament to scrutinize and properly oversight the work of the security architecture of our country. Mr. Speaker, that said, I shall resume my seat without more. Thank you.